Prayer for listing and adjournment, please give it to the court master and inform the other side if you want to take an adjournment.
Lordship. Please, your lordship. I beg to mention item number 9. Kindly adjourn for the day.
You have heard us. I was telling something. Did you hear us? No. Yes, item 1.
Item 1.
In item 1, I pray for some time, like because of the 15th August and all these things, some time is required. Kindly give us time till 22nd or on 27th.
But do you have any instructions otherwise?
Telephonically they said that some investigation is going on. I have no report. On paper, I have no report.
Okay. So because we have to give a short date only as per the High Court rules.
True.
7 days.
7 days. 15 August is there. Can I pray for 22nd?
First. Okay. 19th.
Lord, 22nd.
22nd.
Second.
Holiday 21st year of what is already one property.
We are proposing 21st because 22nd is the last working day after this 2 days of holiday.
Okay.
Even if we have to pass any order,
Okay.
we can't be, will not be able, may not be able to upload.
Not.
So
On
21st. Mr. A.R. Sikdar, counsel for the petitioner, is present on the prayer made by Mr. D. Nath, learned senior government advocate. The matter stands adjourned today to enable him to obtain the instructions and to file affidavit in opposition. If so,
I'll get the status report.
assistant. Okay.
Status report of investigation.
And only got to produce the status report of investigation.
Lodge.
List on 21/8/2024.
Oh, always, madam.
No scoring.
It is unbelievable. It is like a journal.
Item 2 for hearing.
Yes, anything more you have to say?
Lordship.
Anything more you have to say? I think Mr. Dev was required to make some submissions. After some time. After some time.
Item 3 for hearing.
Tinamoni Sharma to Harry আছে Sharma 50 member সেইটো folder folder আহিছে আকৌ two
Petition है petition है
আপুনি ইয়াত বহিব পৰা হ'লেই নেকি?
page 12
Item 2 times item 3 plus সেইটো item 4 নে?
letter is for reminder that the property center force
A reminder. Receive the records 22/9, 22/20. Copy it. Copy application. Photocopy. Exit 12. There is no representation from the petitioner. However, Mr. G. Sharma, standing counsel for the Home Department. Mr. P. Sharma, the government advocate appearing for the Deputy Commissioner. And Mr. A. Ali, standing counsel for the Election Commission of India are present. Next para. In this writ petition, it is projected that against the opinion rendered in FT case number 5/361/MA/16, passed by the Foreigners Tribunal, Gwalpara, 5th, Mornoi, MORNOI, a review petition was filed, which was registered as review case number 3 of 2017. Full stop. It is alleged that all those certified copy of the order orders passed in certified copy order passed in review case number 3 of 2017 was applied for on 14/8/2017. Copy thereof was not provided. The certified copy thereof was not provided. It is also observed that the records of review case number 3 of 2017 in FT case number 5/361/MA/16 has not been received from the Foreigners Tribunal, Gwalpara, 5th, Mornoi. Next one. According to the registry shall call for the records of review case number 3 of 2017 from the Foreigners Tribunal, Gwalpara, 5th, Mornoi. Let us call for.
They will also not be able to say anything unless records are.
List one, give a date after 1 month.
Item 4.
Mr. Sharma,
Lordship.
can you find out from the Home Department if all these FT tribunals, Foreigners Tribunal, they have email addresses? It is easier to call for the records. Otherwise, we have to send it by registered post. When they receive, we don't know. Can you inquire from the Home Department if email address is given to all these Foreigners Tribunal? It is easier for us to communicate. Otherwise, it takes long time to get the records.
Yes, Lord.
And we are now getting in admission cases of 2017-18.
Yes, Lord.
So unnecessarily, there is a gap of 5 years, 6 years. And it is increasing our pendency here. Please speak to someone
Yes, Lord.
having authority in the Home Department
Yes, Lord.
so that this emails, we can get a list of emails.
Yes, Lord. Item 4.
Yes, Mr. Hussain.
Yes, Lordship. Lordship, this writ petition has been preferred by the by one son of the proceeding who expired during the
How-
proceedings.
How
Lordship.
have you linked yourself to your father?
I have submitted voters list, Lordship, of the page 20, Lordship. At that time, legal year certificate was not available. And so I have filed a voter list showing the name of the proceedee along with the name of the present petitioner, Lordship. At
Where is
page
that?
20, Annexure 2, Lordship.
Annexure 2.
Yes, Lordship. Page 20. Rafizul Haq, the last name at serial number 867, Lordship,
Just a moment.
page 20. Item 4,
Yes,
Lordship. Abul Hussein was the proceeding Lordship who expired during the proceedings, Lordship. After his evidence, he expired, Lordship, on the day of argument. And the judgment was passed after his death, Lordship.
just a moment.
Lordship, the
The
death
evidence
certificate
was
is
on
in
which
page
date?
19. Lordship,
On which date was uh,
the proceeding expired on 17/3/2017, Lordship. The death certificate is
proceeding is
Abul Hussein.
Abul Hussein?
Yes, Lordship. Abul Hussein. Page 19 is the death certificate, Lordship.
He died on?
He died on 17/3/2017.
But
Lordship.
there's a legal issue which arises here, notwithstanding that this writ petition was filed long back,
Yes,
but the question is, appeal is normally filed by someone else, say legal hair, only after taking leave, because this is a writ petition.
Lordship.
In a writ petition, how would a challenge by the proceedings legal representatives be maintainable? Because every proceedee, even if you are a son of the proceedee,
Yes.
still to declare you as a foreigner, there must be a proceeding initiated against you. So you still have a right of defense.
Have you received any notice after this?
No, Lordship. The case was decided on 6/4/2017, and the writ petition.
Against your father?
Yes, Lordship. Against my father, on 12/7/17, I have obtained the certified copy of the voter list, and thereafter this writ petition was filed.
No, Mr.
within
Hussain,
the short time.
Mr. Hussain,
Yes,
you see, as per the foreigner's order,
Lordship.
against every proceedee, against any person who's to be declared as a foreigner, there must be a proceeding drawn up. Even if, let us assume for the time being that your father is a foreigner.
Lordship.
You are claiming he is not, but
A
let us
foreigner.
presume for a time being that he is a foreigner. But still, as a son, to deport you and to identify you as to tag you as a foreigner, there must be a proceeding.
Yes, Lordship, there must be a proceeding, but.
So,
Lordship,
can we, what do you call? You see, therefore, I think we will not be prejudiced if we close this writ petition by giving an observation that this declaration by the tribunal would not come in the way for you to take appropriate defense. And if that is taken, the what do you call this? It will be independent of this opinion.
Lordship, that can also be done, but Lordship, my humble submission here may be same, Lordship, in the ensuing opinion, Lordship, the reason why the petitioner herein, the son of the deceased proceeding, approached the honorable court is, dear Lordship, because in the operative portion of this order, Lordship, at page 22, Lordship,
22.
no, Lordship, he has given some additional direction, Lordship,
Where is that?
which will, Lordship, page 30, Lordship. Page 30. it is held, last paragraph, Lordship, that the proceeding is a foreigner of the post 1971 stream and illegally entered India, Assam, on or after so from the specified territory. However, at the time of passing the order, the advocate of the proceeding has filed a petition so stating proceeding has expired and has enclosed a copy of the death certificate of the original. Under the circumstances, as the proceeding has already expired, as reported by advocate for the proceeding, the name of the proceeding be deleted from the electoral roll, ration card, land record, LPG connection, electricity connection, and from the list of the beneficial schemes under the government lordship. So this consequential order lordship, that is illegal in view of the orders passed by the Home Department subsequently. In view of this order, there was urgency that if the name of the father is deleted and he is considered to be a foreigner, then all the benefits availed by the sons and daughters of the petitioner, the proceeding will be jeopardized. Hence, they approach this honorable court lordship.
What is the exhibit number of your land document and which page it is there?
Lordship?
Your land documents are at which
Yes,
page?
land documents. Land document lordship, it is in the record lordship. The evidence is here. The copy was not so legible, so that is not enclosed with my writ petition. However, that is in the record lordship. The original word,
Exhibit number?
yes. Exhibit number 7, 8, and 9 lordship. I have collected the original subsequent lordship. The original were protein original. Those are in the record, and I have the originals also lordship. Exhibit 7 is a sale deed lordship of 1967, April 1967.
Why it was rejected?
Lordship, it is rejected. The explanation has been given in the
No, just tell us.
lordship. The learned member went to calculate the time of death lordship. As the proceeding was asked that when your father expired, he told before the tribunal under section 165 that my father died around 55 years ago. So the learned member calculated this from the date of evidence, and he found that the date of death might be around in 1967 or 62. So counting on it, the learned member discarded this evidence because if the person died in 1967, how he could have executed this sale deed? 67.
Yes, Mr. Sharma.
What is that, Lordship?
So what is the legal position? What is the legal position insofar as the uh, issue which we have questioned? That is whether the subsequent whether the legal representatives of the deceased proceedee can take a defense independent of the documents of his father. Here, this Abdul Mannan, Abul Hussain,
Yes,
he had died.
yes.
Now, son is
Lordship.
son is before us.
Law is that, Lordship. If person died, Lordship, then Lordship, this regarding that, Lordship, eh, in respect of other family members, Lordship, there should be a independent reference in respect of.
No,
without reference, Lordship.
independent reference is one part.
Yes, Lordship.
Second part is the same set of documents which the tribunal has discarded for father. Will it operate as a res judicata for the son?
Yes, Lordship.
See, a document X is discarded by the tribunal saying that it is not reliable
Yes, Lordship.
and it is rejected. So that piece of evidence, can the son rely on it? Although it's an independent reference. Because then there is no point in
without-
sending it. If let us say that the voters list of 66
Yes,
it
Lordship.
discarded. Now son comes. For him, it cannot be acceptable.
Yes, Lordship.
So then what is the point in the in a fresh what do you call sending him for a fresh reference? That is the issue we are trying to understand.
Without leave of the court, Lordship.
No. Leave and all is something else.
Yes, Lordship.
We are
They have to-
this is a writ petition of the year
2017.
2007.
2017. So but that is not the court query. The query is the son is before us. The documents were rejected by the tribunal for his father. Father died
Right.
before judgment. Now there is no reference against the petitioner.
Yes.
Now certain exhibits were discarded by the tribunal, saying that these are not relevant and did not prove his citizenship. Now if we close this matter, will it be a res judicata for the petitioner to place reliance on the same set of documents?
But that point, your lordship, what my understanding is, because there will be a new reference, if there will be a new reference against him, then only he will have to appear before the tribunal.
No. You see, my thinking process is very simple.
I understood, my lord, what your lordship is.
A is the holder of a land.
Yes.
He claims right title and interest. Tribunal, the court rejects it.
Yes.
Now, can the son come and raise a claim with regard to this right title interest for the same land? The answer is no.
Yes.
What is the law in the parlance of foreigners tribunal?
My lord,
A set of evidence is discarded and rejected for the father.
yes.
Same set of evidence for a son. Will it be res judicata?
My understanding will be yes, my lord.
Yes.
Yes.
Then we have to adjudicate this writ petition.
Yes, my lord. That's why, my lord, in some cases, earlier in numbers of cases, we allowed them to implead themselves to fight out the case before this court, my lord, legal heirs. Otherwise, my lord, that may cause come as res judicata in the case.
Belongs to even another category. He expired before the,
Yes, Lordship, before the
Opinion.
judgment,
before
before
the
the
opinion.
opinion. Yes, Lord.
Before the
Before
opinion.
the opinion.
So in effect, the opinion was rendered against a dead person.
No, that's why, my lord. But
In other cases, against the opinion when the writ petition is pending.
Yes.
During the pendency, proceeding expires and then
Yes.
legal heirs are implemented.
my lord, then, my lord, what, that's why, my lord, last reason I submitted before your lordship, that this matter may be seen properly, my lord, adjudicate properly, what may be the proper way of, my lord. Otherwise, it will be confusing, my lord, because there is no set of law, no set of rules, my lord, set up in the tribunals. The tribunals, my lord, their understanding as per the, my lord, settled for the other principles of.
No, you see, for that, there's no requirement of, what you call, going deep into it.
Yes.
We are in a writ petition.
Yes.
In a writ petition, if we find that the right of any person is infringed, then writ petition is maintainable.
Yes, my
We don't have to go and search for the settled law in the position.
Yes.
So when the petitioner comes and says that his father was wrongly declared as a foreigner and therefore operative part of this order is that you cancel the name of his land. How can that be ordered?
my lord, if
You see, foreigners tribunal cannot give an opinion that cancel the land.
that is the subsequent, that act
No, no,
has
no.
to be done by the, my lord.
But can a land go like that? Can somebody's right title and interest
If he's a
vanish
foreigner,
like that,
my lord,
even
that
if he's a foreigner?
no, if he's a foreigner, my lord, foreigner cannot acquire land in this setup.
Then the government will
Government
take
will-
it to courts.
That is the,
So
my lord, duty of the government, not the
cancellation
tribunal.
of land
Yes,
in the name of a pata holder is an order which either the government can pass or it will be the
Yes.
revenue authorities.
my lord, tribunal cannot direct that. That is obviously, the tribunal cannot direct that.
So there is a
Tribunal
there is an
cannot
issue
direct.
which we can decide. So in light of that, we are asking you. So there must be some law which has been settled by this court
Yes.
with regard to the opinion rendered in the name of the father and whether res judicata operates or not. Yes, you are aware of any case laws?
As of now, I am not.
Yes.
Res judicata.
You are aware of any
Judicata operates
case
in
law
tribunals. Tribunal's opinion against tribunal opinion, there is res judicata operates, madam. That is the position as of now.
it operates as a res judicata?
But
Then
because
we do
Okay.
not go into the technical issue as to whether he should take a leave to file a writ petition because this is not an appeal.
yes,
It's a writ petition. If a right of a person is infringed, definitely we can take it up.
we are not objecting, my lord. Then it has to be seen and merit, my lord.
It will give. CBC tonight. Oh, it will do. Mhm. It will 24 to 6.
The hearing. After hearing.
Technically, that's all.
Yes, sir.
Process 6470.
73 was fixed for arguments. Proceeding is absent, the government pleader is absent.
Mhm.
Advocate for proceeding has argued the case on 73.
What did the hearing of 73th? He died.
That's right. You filed a petition on 17.3, saying that he is not well and etc. Maybe now he concluded the hearing. Petitioner, advocate for the argued the case. Right. So the hearing concluded. Right. It was informed that he had expired on 17th. Then after 10:30. Anytime after 10:30. When did he expire with you? That presumption. Mr. Payeng, the report reveals that the hearing was conducted on 17/3, on a day on which date the proceeding expired. Judgment was delivered on 6/4.
Maybe no. I'm not,
Opinion, sorry.
I have not gone through the record, but it is, it may be correct, madam. But I don't know whether it was my lord, communicated before the tribunal or not.
No,
No,
there is a
here,
record. that
here on
you filed a petition.
17/3, he was ill.
They filed a
So
petition.
petition was filed that he is ill. But an advocate must not have known that he has died. So 17/3 he died, but 17/3 the argument took place. Because order 22 rule 6 operates if the person dies after hearing. Now, if the hearing and the death takes place on the same day, 17/3. Therefore, we have no presumption that when he died. But the presumption is, the fact is that on the same day, hearing took place and same day he died. So if you take this view, then this judgment opinion would be a nullity. Passed against a dead person. On 17/3 he died. So on this, what do you have to say? Whether it would become a,
But I have gone through the opinion. Opinion has nowhere disclosed that he died prior to the
no, 73, it's last paragraph
Last
it says.
paragraph, last
It says,
page 30,
17/3
in
expired on
internal
7.
page 9.
Yes,
and 73 is the date when hearing took place.
Seventeen-three. Let it come after some other day, my lord. We may examine this issue, whether it can be done or not. Later. Because this will be a legal issue, my lord. Otherwise, this will be, my lord, settled position, because in the tribunal, in some cases, as your lordship has seen last occasion, we have seen a case where the tribunal has denied to pass an opinion because the person has died. And now some tribunals are taking, my lord, even after death. So this may be uniform. There should be uniformity, and it may be settled by this legal court. But this, you cannot do this way. So this may come in some other time, some other day, my lord. We may examine the issue, my lord.
But against the present writ petitioners,
There is no reference,
there
probably,
is no reference.
Your reference as of now, Lordship.
no reference. Only challenging the opinion of the my lord father. Because
Otherwise,
his
we
right
are
may be,
affected,
his
Lordship.
right may be affected. Okay.
Otherwise, we are actually affected.
Because he is affected by the subsequent orders.
Yes,
Cancel the ration card, cancel that.
not only that, my lord, even the declaration may also go against him, because the declaration that he's a foreigner, that may also affect him.
Wherever he goes, due to this reason, he is not
Yes.
getting the facilities. If say he
Because
goes
in
for a passport.
NRC and etc.
NRC, for
they
NRC
don't-
also he is.
They will
facing
not be
trouble.
included, their name will not be included.
Yes, Lordship.
Sorry, sorry.
On 3rd September. Tuesday.
Mr. Hussain, on this issue, of judicata, you also be prepared with the case laws. All sides are represented. On the prayer made by Mr. J. Pang, London, negotiating for the Home Department. List on 3/9/2024, so as to enable him to add this put on the so I just wanted on this prayer John today list on 3/9/2024.
Right.
Time being item 2.
My lord, I am sorry, my lord, I was in court number 17, the personal appearance was given in that case, my lord, so sorry.
Do you have any answer to the query? Last time we made some queries.
My lord. Well, it's-
On the last occasion, we made some queries.
My lord. My lord, it will be clear from your, this honorable court's judgment, my lord. My lord, may I give this judgment, my lord, one
Johura Khatun versus Union of India. My lord, paragraph 4, page, my lord, 3-4, line about 5th line, my lord. 6th line. It is also seen that the learned tribunal, as your lordship got it, it is seen that the learned tribunal has failed to discuss the evidence of OPW 2 and 3, and it is also failed to discuss anything in respect of answers given by the OPW 1 and OPW 2 to the queries by the learned tribunal. In the considered opinion of this court, the power of the tribunal, learned tribunal, to put queries to the witnesses is relatable to the provisions of section 165 of the Evidence Act 1872, which forms an integral part of the evidence on record. My lord, here is also in my case, my lord, other has given evidence, my lord. Evidence also, it was put, tribunal has put some questions, he answered. And he categorically stated that the petitioner is his son, my lord. So it cannot be, my lord, denied that petitioner is not the son of the, my lord, Safir Ali Sheikh. And another decision, my lord, I beg to submit, my lord, relationship, and that is 2022 3 GLT, page 816, Korimali versus Union of India.
Please give it again. Name of the parties?
Name of the parties, Korimali versus Union of India.
What is the page number?
Page number, well, I'm giving the judgment is there, my lord.
2022.
2022 3 GLT.
Page number?
Page number, my lord, 816. Paragraph 51, my lord. Paragraph 51, 52, 54, my lord. 51, my lord, here the mother was examined as a witness by the petitioner, my lord. Made it, my lord, paragraph 51, my lord. The evidence of petitioner's mother, in our opinion, is highly relevant and significant, who testified from her direct knowledge about she being married to petitioner's father and about shifting of different villages along with her husband, and also the testimony about the children born to her and the particulars of other relatives. Certainly, the evidence of Kadbanu Nessa, the mother of the petitioner, that the petitioner is her son, is a direct evidence. It will be from it will be from her direct knowledge as the mother. As the evidence of the petitioner's mother, Kadbanu Nessa, who testified as DW3, was not shaken during the cross-examination, it has to be given the credibility it deserves in the light of other evidences, both oral and documented.
How was the evidence led? How she is the mother in this matter?
My
Paragraph.
lord, here is the mother and in my case is the father, my lord, as a witness. Mother was given witness in that case.
No.
Originally,
The inquiry
my lord.
is not whether the mother has deposed or given evidence saying he or she is the son.
My lord.
The inquiry is whether she is the mother. Once it is established that she is the mother, naturally the evidence given has to be accepted. But before you accept it, what are the evidences that has been led before the court, tribunal, to show that yes, indeed she is the mother?
My lord. Section 50 of the Evidence Act, my lord.
The tribunal has set the evidence in this case. And in the facts of this case,
My lord.
what is the evidence that she is the father, he is the father? How have you projected the father from voter list 85?
My lord. Voter list 85, then 97. Onwards, my lord.
So what is the finding of the tribunal there?
Tribunal's finding is that his name is different, my lord. Sofer Ali Sheikh is different person.
Okay. There.
My lord, in the full bench decision also paragraph 120, my lord, the question raised whether Jalil Mandal, alias Jalil Box Mandal, alias Jalil Box Sheikh is the same person or not. My lord, it was held that since the other side has not controverted that evidence, my lord, so the full bench has taken is correct.
Full bench would be Muslim Mandal.
Muslim Mandal, my lord. Paragraph 120. 120.1. 2013 1 GLT 809.
Paragraph.
Paragraph 120.1. $11, my lord, at page 871. Line about 11, my lord, from top. Made it, my lord.
Yes.
My lord, line about 10, my lord, from page 871, my lord. About 10, top, from the top.
Yes.
10th line. By the appellant in her deposition has stated that his grandfather's name is Jalil Mandal. In some documents, his name is also shown as Jalil Box Sheikh, who along with Mukesh Ali Sheikh purchased a plot of land by the registered instrument dated so and so. Such positive statement of the appellant has not been controverted by the state during cross-examination. The witness number 2, Abdul Latif, father of the appellant, has also in clear terms stated that his father's actual name is Zolil Box Mandal, and in some documents his name also reflected as Zolil Box Sheikh. An affidavit shown by him in that regard has also been proved as Exhibit F. The sale deed Exhibit D, which has been proved by the appellant in original, reflects the purchase of a plot of land by Jalil Box Sheikh and another by a registered instrument dated so and so. As discussed above, the appellant could prove that Jalil Box Sheikh and Jalil Mandal is one and the same person, who is the grandfather of the appellant. The tribunal, however, has rejected the evidence of the appellant on the ground that the appellant could not prove that Jalil Box Sheikh, Jalil Box Mandal, Jalil Mandal, and Jalil Box Mandal are one and the same person, which finding is, in our considered opinion, contrary to the evidence on record as discussed above. My lord, in a 2021 GLT, page 330, Mathew Rahman's case, my lord. My lord, 2021 GLT,
2020,
2020, 1 GLT 330. Paragraph 11. Here, my lord says that minor discrepancies in recording. My lord, I am reading paragraph 11. We also find from the record that the learned tribunal has declared the petitioner as foreigner based on some minor discrepancies in the recording of age and also for a non-mentioning of the date of second marriage of the father of the petitioner. However, such discrepancies, in our opinion, are minor in nature and hence, even if found correct, we would not have any materials bearing in the outcome of this writ petition. Moreover, in the decision of the Honorable Supreme Court rendered in the case of Firazul Haq versus State of Assam and others in connection with criminal appeal number so and so arising out of number so and so, it has been held that minor discrepancies in recording of names, age, and address of the family members of the proceedee cannot be ground to doubt his case. My lord, in a latest decision, that is Muhammad Rahim Ali alias Abdul Rahim. Special leave petition number, diary number 20674 of 2017, my lord. Muhammad Rahim Ali alias Abdul Rahim versus State of Assam. Paragraph 41, my lord. In that, my lord, Supreme Court, my lord, held that some spelling mistake, my lord, the minor mistake should be considered a minor mistake, and some minor variation in nature, my lord. And ultimately, my lord, it is last paragraph 41, last paragraph, my lord, last paragraph is said, moreover, in our country, sometimes the title is prefixed or suffixed to a name such that the name same person may be known also by one or two aliases. The tribunal seems to have been totally oblivious to this. My lord, in our country, my lord, some alias, it is common, my lord. So and so alias, so and so. In some cases, my lord, it is possible, my lord. Supreme Court also admit this.
No, nickname we can understand. Alias
My-
is something is very difficult to accept as a general proposition.
Here is the problem, my lord. Sober Ali, whether Safir Ali Sheikh, same person. Father's name is same. And since 1996, my lord, voter list is there. His father's name Javed Ali. And his father's name continues, my lord, Javed Ali, Javed Ali. There is no difference. Grandfather's name, my lord, grandfather's name, Javed Ali. 66 voter list, 70 voter list, then 85 voter list, Javed Ali, Janek Ali, Sheikh, then Saber Ali. It continues. Moreover, my lord,
Yes, you're saying something?
My lord, moreover, my lord, in evidence of DW2, paragraph 2, page 14, page 53, my lord.
Yes.
Lord, Safir Ali Sheikh, the father of the petitioner, is categorically stated, my lord, that I am a permanent resident of the aforesaid address. My father's name is Javed Ali, and my mother's name is Shokina Khatun. I, as well as my parents, are the Indian citizen of India. Opposite party, Rafiqul Islam, is my own son, and he was born about 36 years ago at my own home in the womb of my wife, Rokia Nesa, alias Rokia Khatun. Hence, opposite party is a citizen of India by birth. So, my lord, he is a citizen of India by birth since he was born in that village, my lord.
But there's something, there's a mismatch. We are not able to accept it. You see, there's a huge age gap in your evidence and the documents. This father in 2016 says he's 60 years.
60 years.
So that means he would be born in 1960. 1960, 66,
56.
correct.
Yes, my lord.
But then his other voters list and all doesn't match. It makes his year of birth 1920 or 29, somewhere like that. Just check one of the father is 50 years in 2005. He's 40 years in 1997.
My lord, except 85 voter list, all the or my lord, almost tally with the age, my lord. 97 onwards, almost tally, my lord.
In your evidence in chief, it is different.
No, my lord, considering the age of the evidence, my lord, 60, his date of birth comes 1956. So in 1997, his age, my lord, becomes 57, 40 years.
1957. Inside was
1956 minus 40.
50%.
So
85 by 67.
57 almost same.
It went 97 vote best. Page 22. This one. 55.
1956, they are date of birth, but 27 or age.
Thousand five is 50 years. Nineteen 55. Yes, Mr. Pai.
As your lordship has seen, uh, the petitioner is trying to link himself with was Javed Ali of 1966. Javed Ali, whom he claimed to be the grandfather. Now, Javed Ali, his existence in 1966 is there. Now, petitioner is trying to link himself to that Javed Ali, who is there in 1966. That only link is, my lord, the 1985 voter list, where the father, the projected father and grandfather is linking together, my lord, having together. The voter list of 1985, my lord. So if we kindly see the, if your lordship may kindly see the voter list of 1985, who are the persons there, my lord? One Javed Ali is there, and who is also existed in 1966. Sakina Khatun and my lord Saber Ali, son of Javed, is it about 40 years. So we have to accept, my lord, one Saber Ali is son of this Javed Ali as per the voter list of 1985. Because Saber Ali and Javed Ali is appearing together in a common voter list. So we are accepting that one Saber Ali may be the son of Javed Ali and their, my lord, son and father. Now, the wife of Saber Ali is Rokia Nessa.
No, in fact, if you go to page 20.
Yes.
Where others are Javed, here it is Javeda.
Javeda.
Javeda would not be a male name. So this apparently an error by the
Ali, Javed Ali.
by the authorities.
Yes, yes. It may be yes, but Javed Ali. In fact, it was Javed Ali in the
Javed Ali.
Javed.
Mistake is there, my lord.
My lord, I'm not saying there may be minor mistakes. Minor mistakes,
there.
I have no objection on that, my lord. In fact, we are accepting Javeda may become Javed sometime, and Saber may become Safer. We are accepting that also. But Safer Ali will become Safer Ali Sheikh. Saber Ali will become Safer Ali Sheikh with different age. That cannot, my lord, be accepted at this moment. Because, my lord, after 85, it is okay. 85, if your lordship may see.
But 97 age matches only 1 year difference.
97.
1995.
Yes.
So for the Sheikh.
Safer Ali
Javed,
Sheikh.
age is almost similar.
Consistent, my lord. It is from in 85 he is 40, 97 also he is 40. So it cannot be the same person. If your lordship may kindly see 97 voter list, that's why I want to, I'm trying to say your lordship that this Safer Ali Sheikh, who is appearing in 1997 voter list, it is not Saber Ali. First of all,
But it is same village.
Yeah, I understood,
can't
my
be
lord.
so
Same
much of
village,
coincidence.
my lord. I'm coming to that. Same village, I accept, my lord.
Same village.
My lord, in same village, there can be numbers of Safar Ali. In fact, I can say,
Will that evidence we have placed before the court to say that we can't go on presumptions?
my lord, I am not saying that my lord, it is their duty to clarify that Safar Ali and Sabir Ali is same person. Safar Ali Sheikh is same person. My lord, if your lordship may kindly see, can both these documents, if we examine the 1985 voter list and 97 voter list, can we say both this person are same person from the evidence pressed by them? We cannot say
We are-
because it is clearly different.
Unless you give us some, he has discharged his burden by giving these documents.
My lord, burden,
Now,
I understood, my lord,
it
what
is
your
for you
lordship is.
to dispute it and say that these two are not the same. Kindly look at this document, that document, or whatever else you want to say. That has not come.
My lord, your lordship may kindly say, it is, as the burden is on them, they have to prove it by way of, my lord, cogent, reliable, and admissible evidence. Can this be reliable? Both this document.
Prima facie, yes. because
We
the-
cannot
the-
rely this because,
the
my lord,
Same village.
if your lordship
Same
may
way.
kindly see, voter list of 1990, only this 97 and 2085 voter list. If we compare, this is totally different name. There was, my lord, SABR Saber Ali.
No, no,
And age is 40.
You forget everything. You forget everything. Mr. Day is relying on 4 citations, saying that this name discrepancy in the names with the addition of Sheikh or Bucks it doesn't make a difference. That is one. The second part is that the father came and he said that he's my son.
Yes.
So,
Father, my lord, who came? Safar Ali Sheikh.
Yes.
Safar Ali Sheikh. Safar Ali Sheikh may be his father, but whether Safar Ali Sheikh is Jaber Ali of 1985,
no, you did not ask him that.
so that must only mean.
That question was never asked to him. That are you the same person with this voters list?
My lord, so
We'll,
my
we'll
lord,
tell you
fact,
something.
fact is that must only, my lord, that must.
Let me show you something. Yes, 1964. Evidence certificate.
The Honorable Apex Court, in fact, in that case, my lord, was my learned senior friend is relying. In that case also it is said, my lord, the minor discrepancies can be ignored. But in that case, all the other, my lord, if your lordship sitting facts and circumstances in that case, all the other persons were intact together, all their names were correct, except the name of the, my lord, father, where the name spelling, in the spelling, S has become some M, like that only.
It's almost same.
So it is
Safar
only
Ali,
one
Safar Ali.
in the spelling, one name, only the melody, one particular alphabet is changed. For that reason, it is, my lord, accepted that yes, that can be a minor inconsistency. But my lord, for that, my lord, in fact, though it is, my lord, under the whether it can be accepted or not, there is no exact law. But my lord, the Foreigners Act 1946 has provided what is change of name, how it can be changed, whether name can be changed. And the Foreigners Act 1946, for the time being, your lordship may kindly say. There is a provision, my lord. Change of name in Foreigners Act, my lord. So that may be relevant for some extent in this case. The Foreigners Act 1946, because we are dealing with Foreigners Act, my lord.
No.
Section.
Section 5, my
Mr. Pang, this will come when he is a foreigner.
yes.
Now the petitioner does not claim to be a foreigner. He claims to be a citizen of India.
Claiming citizen.
If he is a citizen of India, then Foreigners Act will not apply.
So, my lord, we are under Foreigners Act. My lord, under Foreigners Act only the proceeding is going on, my lord. Under Section 3 of the Foreigners Act.
No, what
I
lordship
understand.
is trying to say.
Section
is
5
that
may not
section-
apply.
Section 5
May not
is
apply.
in
But I understood,
cases
my lord. I'm
where
not
you are
saying
a
it may
foreigner.
apply, my lord. I'm not saying it may apply. But there is no other provision that whether name can be changed. Only for reference, my lord, as because it's under Foreigners Act, only for the reference, my
No,
lord.
no, you see, those things are very general in nature. We can't propound a legal theory on basis of that. You see, let us say today morning, when we rise for 5 minutes, an astrologer comes and tells me that you are writing Kalyan. Please add Kalyan. It will be very good. And today I decide that yes, okay. Henceforth, I'll be known as the change name. I swear an affidavit and give it to the in the newspaper. Now, on the basis of that, my name changes.
Yes.
What else is required? Now, the fact remains.
Certification.
We are on the legal principles. If somebody comes and says in his evidence that his father's name is X or XAXB, now that piece of evidence, you are saying that under the Foreigners Act, it is his burden under Section 9, 9 of the Foreigners Order. Correct? Now, what else would be the method of discharge of burden? If I say that X and XA is same, and there is no cross-examination. What is that judgment in 1964 Evidence Act? 64 judgment.
Section
Some Bishen,
Rampal Vishay.
Rampal,
That is. That
some Rampal Bishen or something.
with regard to contents of the document.
Huh. '64.
Nancy is to be said.
Hmm. It was the cross-examination. That one he could have certified. He never put evidence. রাজি ইয়ার 1964 কানা না 1964 দুটা বলিব দুটা get it. There's a full-page decision of Supreme Court 1964 on this evidence. Purpose of cross-examination was explained. Okay, we'll come back. We'll take a short break and come back.
Fact in issue. By mere filing of documents without examining its admissibility, without the documents being proved, or without examining its relevancy, it cannot be said that proceeding has discharged the burden. Question of rebuttal evidence by the state will arise only if the proceeding adduces evidence which are admissible, proof, and which have relevance. Secondly, 2018 3 GLT 118. It is Vijay Das versus Union of India versus Union of India. Vijay Das versus Union of India. There are 17, that is relevant.
For what proposition?
That is an oral evidence, oral evidence of the. This one of the judgment, honorable effects court, 2013 4 SCC 465, Para 31 that but his name Ayub Khan, Nur Khan Pathan. Ayub Khan, Nur Khan Pathan versus State of Maharashtra and others.
This is on which point? You are citing
That
this?
is on affidavit. filing of affidavit, whether affidavit can be used as a piece of evidence or not. There are 31.
I think. Yes,
Next is 2002,
just a moment, give the citation, please.
2013 for SCC,
Just a moment. 2013,
13 for SCC,
4 SCC,
465.
65.
There are 31.
Paragraph.
Paragraph 31. It relied the earlier judgment of 2002 3 SCC 25 mother.
Please tell us again why you are citing this Ayub Khan, Noor Khan, Pathan Evidence Act. Which principle you are want to say?
Well, the evidence on affidavit filed by the petitioner, but the proceeding is not evidence as per the Evidence Act.
Which evidence?
The so moto affidavit filed by the petitioner. Because to correct their name, they have filed an affidavit by saying that
Where is that? Which exhibit?
page 29.
29.
Yes. Of the writ petition.
It was filed before the tribunal.
No, it was swear before the notary.
Was it exhibited?
Yes, madam. In evidence, they have written exhibit X, exhibit 10. Exhibit 10 is the affidavit.
Tribunal is also not depending on this.
So fine, we don't think this would be, this would be applicable here. You see, the paragraph you are citing is on the ground that this self-statement is, by way of an affidavit, is not an admissible evidence. There is no quarrel with that proposition. Here, what has happened, the proceedings father comes and says that these are the documents which my son is relying on. In this, there's a name of so-and-so, and therefore, I say that all these three names are same person. So it is only for that purpose that affidavit is sworn.
Yes.
And he has come to the court and he has deposed himself that I am the same person. Father's name is so-and-so and my name is so-and-so. This, he stood for the cross-examination.
My submission is that, that particular affidavit, which was adduced as a evidence, as exhibit 10, my lord. Let me
You see, I will show you something. Try to the open, Raji, CPC dio. Itu. 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 Before I put this question to you, please tell us, according to your understanding of law, in this proceedings before the foreigners tribunal, the strict principles of this
CPC.
CPC and the Evidence Act, whether it is followed or not,
Strict principle of CPC and evidence will not follow, my lord.
it will not follow.
Yes.
Okay. Then, because if it does not follow, then so far as Evidence Act is concerned, the view of the tribunal should be a very strict view or it should be a lenient view.
Well, it's an opinion, my lord.
No, I understand.
Yes.
That's why I'm saying view. The view of the tribunal should be a very strict view or it should be lenient.
My lord, my understanding is because, my lord, it's a matter of, my lord, citizenship. So it should be strict in.
It should be strict.
Yes.
More strict than the Evidence Act is.
No, my lord, it cannot go beyond the
No,
evidence.
I'm just asking you, I'm just clarifying
Cannot go
things.
beyond the law.
Now,
my lord.
see, second thing, if the procedure is not there,
Yes, procedure is not.
then please tell us, we have put this question many times, I'm repeating it again. You see, if some document is questionable document, and if a witness is asked that this is a document which I am disputing, then perhaps he has a option to bring in fresh evidence if the court permits or a tribunal permits. Now what happens if you don't give that opportunity to him to put to him the disability that a document is suffering with, and you keep silent, and the state does not question that, and the tribunal ultimately rejects it, then what happens is non-suited because of a document whose correctness was never questioned. Because then you see, why have it in a tribunal? It can be a regular civil court then. If a strict view of the evidence is has to be read. Because if the procedure is not laid down, it's not the state's case that all people who have been declared, who have been
Referred.
inquiries being ordered are all literate class. And I'll be not bragging if I tell you, I have also seen during my practice time that you don't speak of the literate class in the cross-examination by one of the senior most criminal lawyer at that time. I have seen the magistrates crying. The magistrates who have recorded 164 statement, who have recorded confessional statement. I've seen them when we were young juniors and sitting in the courtroom. We have found that when some seniors cross-examine, a very short cross-examination, they used to started crying. Because the fact is, it's an art of cross-examination. And if you don't put that, the point is that if you don't ask that question, why it should not be treated as an admission by the state. It's a fact. You see, what are the facts which must be decided? A fact must be a fact in dispute. If the fact is not even disputed, it becomes an admissible fact. And then under the Evidence Act, if you say that it's a strict interpretation, then there are only three possibilities. Either a document is proved, it is not proved, or disproved. Now, what strict sense can you take in these three options you are available under the Evidence Act? You see, under the Evidence Act, these are only three things which can be. A fact is said to be proved,
No, that is
not proved, and disproved. That is the interpretation clause. First is facts. Before that is relevant.
yes.
Then we have proved, disproved, and not proved.
I have
By
referred.
not asking a question,
Yes, sir.
where do you put this under these three head? Proved, disproved, and not proved.
My lord, my submission, my lord, your lordship, may kindly, I have referred a judgment just now, my lord, another judgment where it is to some extent discussed that issue.
Which one?
The 2018 4 GLT 360.
2000,
18 4 GLT 360.
3,
60.
60.
Thank you for calling me.
It'll lie you, huh? Daniel. 2018 4 GLT 360.
360.
You have a copy of this Ayub Khan Nur Khan Pathan. You have a copy of that judgment with
Yes,
you?
yes, yes.
Ayub Khan Nur Khan Pathan. You see, the paragraphs maybe one or two here and there. Para 35.
25, madam. 35, madam.
Of Ayub Khan.
Yes.
In started chanted back. You got it?
That's in Standard Chartered Bank.
You read for yourself. We take a break because we have a meeting right now. Resume it too.
Yes.
But read this. We are taking a full length hearing so that our concepts are explained by you, and then because in other cases, then we can concentrate faster. Because this is a legal principles which are in question in almost all the cases.
Yes.
Which judgment? Yes. This goes against you. This paragraph.
my lord, one of the judgment of this honorable court on foreigners tribunal. Yeah. Can you speak?
Paragraph 36 is also important. Ayub Khan, paragraph 36.
And 37.
What is it?
29/0/2018. With regard to procedure, there is judgment of this honorable court, my lord.
So you have to now tell us, in view of the evidence which was led by the OP, uh, trying to establish the link with his father, and in view of the examination of the father of the OP by the tribunal, can it be said that the OP has still failed to discharge the burden under Section 9?
Yes. That must one day I was trying that. Because, my lord, for that reason only, my lord, I was referring this.
Keeping in view the examination by the court,
Yes.
had the examination not been undertaken by the court, perhaps you could have strongly argued that he is not discharged his burden.
My lord, but my lord, one submission is, my lord, can tribunal is the independent body, my lord. Tribunal is not part of the, my lord, procedure, by the government. So can it be prejudiced by that, my lord, only by that questions put by the tribunal?
No, but it's a part of the evidence now.
Yes, it's a part of the evidence now.
It is a
But-
part of the evidence. So who has cross-examined so and so?
Yes.
Who is so and so projected father? And the questions do not uh, dislodge his evidence which is given earlier.
Yes.
No. Mhm.
Which is complete.
13. Like, like to say, you have to give. What do you do? Maybe. Relying on the- One thing, your lordship, even though we accept the federally has given it, this, the federally Sheikh has given his evidence, but how far his evidence, cross-examination part from the cross-examination, how far it is trustworthy, that may also be looked into. How far is it?
Trustworthy, madam. Because,
That is for you to,
yes, your lordship.
you to argue on
Yes.
and tell us.
Your lordship may kindly see in my lord, WS, petitioner has not given how many siblings he do have. He does have, my lord. The petitioner has not given. Plus
I
he
think
has-
there are judgments to that effect.
Yes, the judgments are there. I'll place those. He has, my lord, petition, the WS is totally vague. I'll come to that point, my lord. But one point, he has not given anything about his siblings, my lord. Secondly, father has also not said in his my lord evidence in affidavit, how many siblings he do have. The father have, the projected father. Now from the records, exhibit 6, my lord, says, shows he has 3 sons. The projected father who supposed to came before the tribunal and given the position. But in cross, he has specifically said he has 2 sons and he has given names also, man. He has given only
One is
2 names.
adopted.
Yes. No, he has not said adopted. That explanation is not there.
It has come somewhere.
Yes.
It has come somewhere. When is it?
No, man. That is not there. Nowhere it is there. Nowhere it is there. So this evidence cannot be accepted for that contradiction. Because if we see at Exhibit 6, voter list, this record, it is in record. And in cross, he has specifically mentioned the names also, who are his sons. Like. It is not that he has wrongly said it. 2 may be sometimes written as 3, my lord, or 3 may be sometimes written as 2. But he has given names also.
You see,
Yes, sir.
conceptually, you'll have to make things very clear. You see, number one, what is the purpose of why we have a concept which is called
Procedural.
uh, um, what is called contradiction.
Yes.
So therefore, a previous statement, let us say this affidavit, for example, self-declarative statement. There is no objection raised, no question asked about the self-declaration. I always have a question. I have put this in for more than 100 times in this court. You see, I make an absurd claim, and then I assert that claim before all of you.
Yes.
You want to keep me happy, and therefore you say yes. My lord, that is correct. You want to keep me happy, you say correct. That doesn't make things change. Correct. Now, the purpose of contradiction is that you give the previous statement or the statement to the person and then tell him, how do you explain this? So if there are 2 sons and 3 sons, and there are no cross-examination, that means at that point of time, the state did not take an objection or thought it to be immaterial to accost this person with the earlier statement saying that, well, here you have 2 sons, now you are saying 3 sons. Or earlier you were 3 sons, now you are saying 2 sons. So therefore, you dispute the identity of a person, saying that you are a stooge, what do you call, stooge means a setup person. So those things are not there.
I'm madam, this is in cross-examination, he's contradicted the record, madam. In cross-examination, he contradicted what is there in the record. In evidence, they find, my lord, there are 3 sons. But in cross-examination, he has said, I have 2 sons, so and so and so and so. So it is clear contradiction. The cross part he has said.
Mr. Payne,
Well.
you see, just because of the fact that citizenship is at stake, we are asking you these questions.
Yes, madam.
You see, otherwise your argument would have been an acceptable proposition. But you see, the question before the tribunal is whether the petitioner is a foreigner or not.
Yes.
Was entered into India after 25/3/1971. Whether the proceedee's father has 2 sons or 3 sons is not a subject matter of inquiry. So even if a false statement is given with regard to children, doesn't affect the veracity of that part of the inquiry which relates to the detection of the petitioner to be a foreigner. Correct. Now, when we are telling you about the concept of contradiction, it is always a previous statement which has to be made before him, and then contradiction is made. So therefore, ideally, it should have been asked that in your previous statement, you have said that you have 3 sons. Now you are saying 2. Then his statement becomes whatever he gives may or may not be a contradiction. Correct. So merely because let us say, you see, I give a example. My examples are always horrible, so excuse me. The question is to you, Mr. Payang, in your pocket, how much money you have? You think that, oh, I may have 10,000 rupees with me. And I ask you to count it. Now, when you count, the money in your pocket is 1,001 rupees. Correct. Now, is it contradiction? Your previous statement, you said 10,000.
Yes.
Now I said that I disbelieve that you have 10,000. Please count. You have counted and it is 10,001. According to you, is it contradiction? It makes your statement unbelievable. No. So therefore, for a purpose of contradiction, the previous statement has to be put before the person concerned. And then he should be asked to controvert, and then you question him that, you see, you are not a father, actual father, and therefore you did not know that you have 3 children. Then I would have understood. That is one part. The second part is that a mere question asked and a wrong answer given. We also have the principles of falses in uno, falses in omnibus principle not being applied in India. So if one part of the statement is false, the Supreme Court has said, in not all its wisdom, that there may be a chance of exaggeration, there may be a chance of forgetting, there may be a chance of what you call a false statement being made. But still, it is only that part which cannot be considered. It doesn't make the entire evidence disbelievable. That is a concept. Not to change or to reply to what we have stated. Do you have any case laws on the point which says that a solitary question asked and a wrong answer given would negate the entire evidence? Because you see, there's another principle. Insofar as criminal cases are concerned, the law laid down is to the effect that the harsher the punishment, the stricter the evidence. And therefore, in the heinous crimes, it must be proved without reasonable doubt. So that principle is applied. Now, in this case, a person loses a citizenship. So when you said that strict principles of evidence applies, we can accept it. Acceptable. But the fact is that, is the state not required to say anything? Because a proceeding comes and says that this is my family tree, this is what has happened, this is there, this family is there. There's no question to him. In this case, the tribunal asks a question. So therefore, it's an affirmation of what the petitioner has said. Where is the doubt after the court questions? Is there any case law on the point?
I have referred just one judgment, that's why, my lord, 2018 4 GLT 360.
2018 4 GLT 360.
Yes,
Just try to get a printout. Printout, I see. GLT असा आहे ना? GLT असं येते.
yes, lordship, we kindly take judgment, it is WPC 2641.
Supreme today. ताते पाहिजे हो.
WPC number is there. 2641 of 2017.
Paragraph
Paragraph my lord, 16, 16, look at it.
15
16, 16.
16.
That which on the other hand, my lord. Paragraph 84, my lord. On the other hand, that which
Please read. Yes.
on the other hand, from the impugn order, we find that after narrating the case as projected by the respondent, the tribunal observed that she did not examine any witness and failed to produce any rebuttal evidence. Therefore, tribunal answered the reference against this that we are afraid the approach taken by the tribunal is contrary to the law laid down by the full bench in the state of Assam versus so and so 2013 1 GLT 809, latest Muslim Mandal. Under Section 9 of the Foreigners Act 1946, burden is on the proceedee to prove that she is not a foreigner, but a citizen of India, and this burden never shifts. The burden has to be discharged by the proceedee by adducing evidence which are admissible, which must be proved, and which must be relevant to the fact in issue. By mere filing of documents without examining its admissibility and without documents being proved or without examining its relevancy, it cannot be said that proceedee had discharged the burden. Question of rebuttal evidence by the state will arise only if the proceedee adduces the evidence which are admissible, proved, and which have relevance.
I think this paragraph will not be understood unless you read paragraph 14.
Yes.
Because in 14, what happened was the document was brought,
Yes.
but the author was not examined.
Yes, ma'am.
It is in that context that paragraph 16 is the finding. Here, that is not the case. Not a single document is there where the author has not been examined. And once a certified copy is issued by the election branch, you can't say that the certified copy has to be proved by the original, what do you call the official, through the official records.
But effect also, my lord. Another judgment.
No, judgment is okay. Please explain the principles because we must understand on the, you see, a judgment is an authority on the facts on which it is decided.
Yes.
So unless we, because otherwise, a paragraph from here and there.
Yes, my submission is that, my lord, in the present case, if your lordship see, my lord, the father has deposed before the tribunal, and he was cross-examined. As your lordship, I have said that I have not said that the evidence of the DW2 is not, my lord, not admissible, but how far it is trustworthy. because of that method contradiction. That statement, how trustworthy of the method, because
You have to explain the basics. You must proceed as if for the you see, you'll have to explain. Number one, is this you see the principle of evidence shifts into it can be viewed in two ways. For a criminal, in a case which is having a penal consequence,
Yes.
it is the evidence to the what you call strict rules of evidence.
Yes.
And when it comes to the civil principles, it is the preponderance of probability.
yes,
Correct. Now, is there any judgment where it says that in the criminal in this foreigners tribunal cases, the rule of evidence would be a strict rule of evidence?
that is not there, madam.
Then it is then it is preponderance of probability. There can't be any third theory.
They read out a judgment of the on that effect, madam.
No, no.
Is in
What
fact,
we are saying is that you see, to say that it is trustworthy is a third proposition.
yes,
If it is not trustworthy, it is said to be proved or not proved. Sorry, disproved or not proved.
yes,
But when it is a civil consequence, the preponderance of probability is there. So therefore, trustworthy, even if it is not, but preponderance of probability is an acceptable proposition.
in that case, madam. In civil, madam, it may be acceptable, but in criminal jurisprudence, it may not. That is the point, madam. So one judgment, my lord, with regard to that case, because to clarify the issue, my lord, because what procedure we have to follow, that there is a judgment of reasonable court in Rukia Begum. I'll read out slowly, my lord, in that. Because if what procedures, because we are always in confusion as whether civil procedure as CPC will exactly follow or not, whether the evidence will exactly follow or not. To that point only, some discussion is there in this.
Which decision?
This is WPC 6344 2016.
2016.
My lord, 6344 2016.
2016.
Yes, 6344 2016, decided on 29/5/2018.
Oh, this is an unreported judgment.
No, my lord, it is probably not reported.
25. Date of disposal.
29/05/2018.
You want to strike it on the bench, DB or
Division bench.
Foreigners matter.
Yes, madam. Foreigners.
Okay. What is the name of the parties?
Rukia Begum. Yes. Rukia Begum versus Union of India. RUKIA. Rukia Begum.
IUKIA.
Yes. Rukia Begum versus.
IUKIA.
Yes, ma'am. RUKIA. KIA.
Okay, not getting. Let them find out. Just a moment.
This one. This one. That is- Patient. In piece format.
Yes, which paragraph?
In piece four, my lord, it is probably paragraph number is not given.
Page 4.
Piece four,
Yes.
from middle, my lord. Insofar as contention.
Yes.
Yes. Insofar for contention of learned counsel for the petitioners that since the state did not raise any objection as to the filing of such certificate and mark making of the same as exhibit, therefore the said certificate should be accepted as a valid piece of evidence at
Sorry,
its
sir,
face value.
You're reading from which paragraph?
It will insofar as.
Paragraph second,
Page number 5.
page four, my lord.
4.
Insofar as.
Yes, insofar as. Probably page number maybe different. Insofar as. Insofar contention of the learned counsel for the petitioner that since the state did not raise any objection as to the filing of certificate and marking of the same as exhibit, therefore the said certificate should be accepted as a valid piece of evidence at its face value. We are afraid we can accept such sweeping contention on behalf of the petitioner. Under paragraph 3A3 of the Foreigners Tribunal Order 1964, Foreigner Tribunal shall have the power to regulate its own procedure for disposal of the reference expeditiously in a time-bound manner. Therefore, while conducting a proceeding, a Foreigner Tribunal has power to regulate its own procedure. Paragraph 4 of the order says that the Foreigners Tribunal have the power of civil court while trying a suit under the Code of Civil Procedure 1908 in respect of summoning and enforcing the attendance of any person and to examine him or her in oath, requiring the discovery and production of document, issuing commission for the examination of any witness, and directing the proceeding to appear before it in person. Therefore, applicability of the Code of Civil Procedure to the proceeding before the Foreigners Tribunal is confined to the four situations as enumerated in paragraph 4. A proceeding before the Foreigners Tribunal is summary in nature and having regard to the scheme of Foreigners Tribunal's Order 1964, it will be too perfected to hold that detailed rules and procedure laid down under the Code of Civil Procedure and practice in the civil court shall be applicable in letter and spirit in a proceeding before the Foreigners Tribunal. A Foreigners Tribunal is not bound by the strict rules and procedure provided under the Code of Civil Procedure. This is more so because in a proceeding before the Foreigners Tribunal, burden of proof is always on the proceeding, and he has to prove that he is not a foreigner, but a citizen of India by adducing evidence which are admissible, proved, and relevant, which having regard to the mandate of Section 9 of the Foreigners Act. The burden which lies upon the proceeding never shifts. Therefore, the evidence that is tendered by the proceeding must be admissible in evidence, must be proved in accordance with law, and must have relevance in the fact in issue. Just because objection to the documents marked as exhibit by the proceeding is not taken by the state would not make the document admissible in evidence if it is not otherwise admissible. So it is said, my lords, details procedure of CPC may not follow. Next bit also important, my lord. Having said that, we may avert to the case in hand. In view of what we have discussed above, we are of the firm view that since petitioner had placed a reliance on exhibit 1 certificate, that is probably the school certificate, burden was on the petitioner to prove that seed certificate as well as the content thereof, irrespective of whether objection was raised by the state or not.
Case,
Yes.
how would you like to apply this case?
No, actually, I was referring this only for the purpose that, my lord, the CPC, whole procedure followed in the civil under the CPC, it may not be accepted in the tribunal.
We are in agreement
Yes,
with that.
yes. Only for this purpose, only these four reasons, my lord, for summoning and for attendance, only for these purposes, the CPC will apply.
The repeated use of the code.
Yes,
Right? The burden is on the proceeding,
yes,
and you'll have to prove it.
yes.
Now the question is whether the document has been proved and is relevant or not.
My lord,
Some view or some opinion will have to be rendered.
Yes.
yes. My lord, your lordship may kindly see another issue, my lord, in the WS, the evidence. Because this, my lord, it has to be looked into because the facts and circumstances of the case, my lord. What he has stated in the WS, my lord, in the WS, what is he has stated? WS page 39 in the writ petition. Because this is very important. Because the father has disclosed that he has two sons, my lord.
W is it at
Page
page?
39. Page 39, my lord. He most humbly and respectfully, the above name opposite party submitted the written statement before the Honorable Tribunal as follows. That there is no cause of action against the answering opposite party, hence the case is liable to be dismissed.
Just a moment.
Yes. The WS Lordship Fund, what he has stated only, number one, that there is no cause of action, that is there. Number two, that the case has been filed before your honorable tribunal by the superintendent of police, Bongaigaon, only to harass the opposite party, both economically and mentally. Number three, that this case has been filed by the superintendent of police, Bongaigaon, to mislead the honorable tribunal and was the valuable time of the tribunal without proper investigation against the opposite party. Number four, on what minority has given some, that the ensuring opposite party is bona fide citizen of India by birth and permanent resident of Assam, residing in village Kalikura, Part 1, within the residence of district of Bongaigaon, Assam. Here, my lord, he has nowhere mentioned when is his date of birth, and to that effect, there is no evidence at all. That father of the opposite party was an Indian citizen and permanent resident of Assam, and his grandfather name has been endorsed, enrolled in the electoral rules of 1966 under Abhayapuri constituency, Assam under East, while Gwalpara district by serial number so-and-so, voter number so-and-so, at village so-and-so, Kalikpuri, as Javed Ali, son of Janik Singh. A photocopy of the certificate copy of the voter list of 66 is annexed. Then the name of the grandfather of the opposite party has been enrolled in the electoral rules of 1970 under Abhayapuri LIC, Assam, under the East, while Gwalpara district, so saying so-and-so, at village so-and-so, as Javed Ali, son of Janik. That the name of the father of the opposite party has been enlisted in the voter list of 1985 at Abhayapuri LIC, house number so-and-so, place so-and-so, Kalikuri village, as Saber Ali, son of Javed Ali. Photocopy of 85 voter list is there. Then the name of the opposite party has been enrolled in the voter list of 1997 under so-and-so, 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 and polling station so-and-so, Kalikura LP school, village so-and-so, as Safir Ali Sheikh, madam. Safir Ali Sheikh, son of Javed. Photocopy is annexed. That the name of the opposite party has been enrolled in the voter list of 2014 as so-and-so in Abhayapuri LIC, Kalikuri, village Kalikuri, as Rafiqul Islam, son of Safir Ali. Then the ensuring opposite party has reserved the right to additional written statement before your honorable tribunal is required. Then this writ petition is filed one up. So this is the only written statement. Now he has not explained, given anything about his mother, anything he has, that whether he has any siblings of his own or not, and he has not given what is his date of birth.
You have the records with you?
Yes.
Please pass it on.
No, that's all, my lord. My only submission is that, my lord, on this context, there is some judgment. I can furnish, my lord, the judgments of this on whether the, yes, yes, yes. Yes, yes, my lord, my only, my lord, I have to clarify only one thing, my lord. He's relying on 1976, 66 voter list and 1985 voter list. 85 voter list has, yes, difference of age and difference of name. My lord, the 85 voter, the 85 and my lord, 66 is consistent, but differ from my lord, 97, 2005, 2014, which is relying. So these are not consistent with those, my lord, 85 and 66 voter list. So yes, yes, that judgment has clearly said. That in the opinion, opinion, yes. And one thing, my lord, the tribunal, by asking that question to the, my lord, procedure, tribunal cannot prejudice the, my lord, the stat also, because stat has not met. Yes, 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 yes.
Yes.
Cross-examination. Confirmation of the statement. Maybe on 22nd, madam. 20 I may not be available. 20 I may not be available. Any other date, madam? Yes.
Item 7.
Lordship, in this case, the petitioner expired. Yesterday, we got to know from the local council.
Come out to this side. You have a copy of the death certificate?
No, Your Honor, we'll obtain on the next day. Kindly. We got the information over phone.
No, it's okay. Thank you. You are the advocate on record. Your Wakalatama is here.
No. I'm on behalf of ASOMO.
You asked Mr. Thomo because you are not a counsel on record. And your
Because-
submission without a certificate.
Either you produce a certificate or let Mr. Shamua make his submission. Okay. We'll list it
Time
after a
may-
week. We'll list it after a week. Okay. Mr.
AR Kashyap
A.R. Kashyap,
on behalf of
appearing on behalf of Mr.
ASOMO.
A. Samua, counsel on record for the petitioner, submits that as per instructions received, the petitioner has expired. Full stop. He prays for some time to obtain a written instructions or a death copy of death certificate to be produced before the court. Next, list, after how many days?
One after one.
List after a week.
Obliged.
Single bench, item 1 to 6.
You had last from the impugned letter dated 29/1/2021. Then you came to show cause notice at page 134 to 145.
29, there is a mistake probably. 21/9/21, it should be 20 pro. Page, how much?
Okay, 29/1/2020.
Probably, and let me check it.
Okay.
Because we filed this case in 21. Let me check it.
29/1/2021 is the impugned note.
Show cause notice.
Yes. That was the earlier order, not the recent.
No,
order.
I
That
don't
was
know. This
the-
last submission I have recorded here is page 134 to 145. These are show cause notice signed by the division
Yes.
manager. And prior to that, the impugned letter of FCI is dated 29/1/2021, which is the impugned letter in this writ petition.
Page number?
You were last referring to page
Page number
42 to
121.
91. You were last referring to page 42 to 91.
40 to 20.
And you are saying that this is the impugned letter dated 29/1/2021.
40 to 20.
And then you were referring
Yes,
to
sir.
the, then you were referring to,
29/1/2021.
then you were referring to page 134 to 145, which are the show cause notice.
Hmm.
And you were last making a submission that they were signed by the divisional manager.
132, no?
Yes, 134. And then you were perhaps questioning his authority to give that notice.
Yes, yes, yes. I know.
Prior to that,
Yes.
your last submissions, I'll just narrate this. You were last referring to the High Court order.
Ah.
And then you were saying that that principles of the, that direction in the High Court order was applied to all the laborers.
Yes.
And then you were trying to say that this is the 29/1/21 is the impugned order. And then you are questioning the show cause notices signed by the divisional manager. You are perhaps questioning his authority.
Yes.
That is where you stopped.
But basic is a simple. At best. Authority concern issued a show cause notice. And I have been directed to reply the show cause notice. I have submitted my reply. Though I have not annexed this reply, that is your lordship would find in the order itself. That is 31/12/2021 order I'm done. I have submitted my reply. All the workers submitted their reply. It was identical. Now, again, we have been called upon, workers have been called upon for personal hearing. We appeared before it. And our submissions, it was in Hindi, our submissions were recorded. Thereafter, order was passed. The person concerned who issued the show cause notice, he has considered my show cause, reply to the show cause notice. It took judgment about the AIR 84 judgment. Class no copy. Right.
What is wrong about it? If he's the competent authority, for example, let us say,
Let me come. A person should not judge his own cause. That is the basic principles of natural justice. I have issued my proposed notice, and I have directed someone to submit his reply. All right, he can submit his reply, no problem. I issued the proposed notice. You have to supply a reply. Yes, all right. I will find this reply. I am not satisfied with the reply. This much there is no problem. Thereafter, I have decided to initiate an inquiry, as I am not satisfied.
no, but under Assam Service and Discipline rules, the authority concerned who is to issue a show cause notice must be a disciplinary authority.
Yes.
So he is the person who will receive a reply. He is the person who will be satisfied or not satisfied with the reply, and he
Yes.
will direct the proceedings to be taken up.
I issued a show cause notice. Definitely, I will consider. I have issued the show cause notice. It is incumbent on your part. So far the show cause notice is concerned, I simply indicate as to why a disciplinary proceeding will not be initiated again. This is much. In every sort of inquiry, it is alleged that you have done this thing, that thing, that thing. So this show cause notice is issued to you, or the charge sheet is issued to you. So you have to submit your reply and explain as to why a disciplinary proceeding will not be issued, or as to why necessary action will not be taken place. I submitted my reply. If you are satisfied with my reply, then you will not proceed with any inquiry. Matter will end here. If you are not satisfied with my inquiry, my reply, then you will initiate an inquiry against me. Now the question is that whether I am entitled to hold this inquiry. I am the accuser. You have submitted your reply, and again myself is holding the inquiry.
There is something I have done today also.
Huh?
There is something I have done today also.
I don't.
Yes, this is something which has happened today.
Hmm.
I did the same thing. Because you see, by virtue of my position, there are certain things which are within my domain. On the administrative side, there are certain things which are placed under my domain. So if there is something wrong happening to the officer, I'll be the first person who has to charge him.
Yes.
And on my basis, since I don't communicate, the registry will draft a letter
Right.
on instructions.
Yes.
And then after this proceeding is drawn up, it will be at my authority that the proceedings are drawn up.
Yes.
And the proceedings drawn up will be placed before me only.
Yes. But whether your lordship can hear him or not. Because
I have to
your
do-
lordship has framed a chart.
I
And I have been called upon to.
You
give
see the
answer.
Assam Disciplinary Service rules. See the Assam Disciplinary Service rules.
TCS rule also says so.
No. This is absolutely incorrect. And sorry to use this word. I'm sorry, very much sorry. I should not.
It's okay.
No, let me go through one judgment. That will clarify this.
Oh, citation থেকে
Yes, copy the name.
Oh.
আমার রিটার্নের কোনো লেখা আছে তো?
Because the principle I understand.
No man should judge his own cause.
No, that's okay. But I'll tell you what is happening in the service parlance under Assam Disciplinary Service and Appeal rules. What happens is that the disciplinary authority initiates the process, and he may It's
I
not
have
mandatory.
understood. I have
He
understood your
may,
logic.
no, he may ask for an inquiry. And if he's the himself as is the inquiry, he's himself carrying out the inquiry, then he does not have to give a second show cause notice. It is only after,
Your lordship has decided to hold an inquiry. All right. Then your lordship will pass such an order whereby some other person will hold the inquiry. It
May
may
not
be of
be.
the same time.
may not be. Under some disciplinary rules, it may not be.
I have not. Oh, yeah, let me go.
I'll show you that. I'll show you that provision.
Same person cannot be blood. Yes, yes. Same person.
No, my learned colleague is right, but the charge should be, if the charge is, there's a bias on the charge. Supposing there's a charge,
No,
in this case also, my learned friend has referred, the charge was he entered into the room, the disciplinary authority. So therefore, he cannot. That's the right, my lord. That's
that is AK Kaipa case I brought it, blood. No, 84
Look, 9-4, I'm just putting a pencil mark.
blood.
Page 12.
I will go through it. Blood. Let me.
It's just clearing of concept.
All right. That will be better. 9-4.
9-4.
On receipt of the written statement of defense, or if no such statement is received within the time specified in the disciplinary authority, person concerned, a disciplinary authority by a number of persons. Disciplinary may itself inquire. Yes. Disciplinary,
then next.
Disciplinary authority may itself inquire into such charge order as not admitted, or if it is considered necessary to do appoint for the purpose of board of inquiry or the inquiring officer. Yes, no problem. I am the disciplinary authority. I will. Disciplinary authority means a number of persons of rank. Disciplinary authority means say for example, a rank having a number of persons.
May not be.
Or
May not be,
person
because
concerned who.
If your matter is assigned to me, I'm the only person. There's no.
No,
even
yes,
if-
there is an exception. Yes, there is an exception. Under the natural uses, that is called the exigencies. If there is no such person, then I shall do it. That is exigencies. But disciplinary authority, a set of officers are there. A number of
No, for
officers
example,
are there.
managing director.
The person,
If the disciplinary authority of a company is a managing director or a
Yes.
director,
huh,
what you call, or he's a general manager, there can be only one person also. Only the general manager is only one person.
disciplinary authority is a cadre of persons. Not only one person. A set of persons will be representing. Sometimes it may so happen there is only one person. There is no other persons. If there is no other person, then the doctrine of exigencies will come and do this thing. There is a number of judgments. I will bring it if required. Under what circumstances this rule can be dispensed with. That is called exigency. You also can note it. I will bring this judgment. Now, say for example, in a bank, disciplinary authority is grade 2 officers or grade 1 officers. Grade 1 officers are the disciplinary authority against the person concerned.
For example, you see, this is something which knowledge I have acquired while sitting in the bench. Assam Cooperative Apex Bank. The disciplinary authority for officers is the managing director.
Yes.
So one person. There can't be two managing directors in a bank.
Disciplinary authority
Is the managing director.
the appointing authority.
He's the appointing authority.
Yes, yes, the appointing authority. Appointing authority.
Is the that managing director?
No, appointing authority may be a disciplinary authority. And the disciplinary authority may be other persons. Every appointing authority is disciplinary authority. And apart from that appointing authority, there may be other persons who may be called as.
Maybe.
I will bring it, Lord, if so required.
No, not required. It's not for this inquiry, but since I had a concept, I told you that this is my concept.
No.
Because I follow, because
No,
for this, for my purpose, we follow Assam Discipline Service. So therefore, this is a scheme which I understand.
No, on receipt of a written statement of defense, or if no such statement is received within the time specified in the disciplinary authority, person called disciplinary authority may itself inquire. Disciplinary authority may inquire, or any authority above the disciplinary authority may inquire.
No. Inquiry will be lower always. It will be always by a lower. Because if I have to make an inquiry, I'll have to ask my registry. They are a rank below us.
Any
Superior authority cannot, because then you will say that I am influenced by the authority of my senior. I can't ask the Supreme Court just to make an inquiry.
disciplinary authority.
Disciplinary authority, disciplinary authority would be the person who is the what you call
Above the appointing authority, may be disciplinary authority.
Oh, yes, that is a different way.
Above the appointing may be disciplinary, should not be below the appointing authority. Disciplinary authority should not be below the appointing authority. But
Correct.
for the appointing, above the appointing, no problem. So I am the appointing authority, and I may be the disciplinary authority. So a appointing authority, a number of group officers are appointing authority. A, B, C, D. Designation is same. Let his designation be X. Now, Mr. X has issued a charge sheet to Y. And Y has been called upon to show cause. And Y submitted his show cause reply. Then X has formed an opinion, rightly or wrongly, that your reply is not satisfied to me. So we have decided to hold an inquiry. Now the question is that X, who has issued the charge sheet, X, who had considered the reply to the charge sheet, can conduct the inquiry or not by himself, or X may call upon, or X may delegate these things to some other person of his rank. He may be a rank of X, but he should not be the person X. Now, let us take a cut at this.
We can explain this.
Uh-huh.
That's.
It is a attention. I got attention. Sorry, I have brought this AK carpet case. May I read?
yes.
I'm sorry, I
No, it's
cannot
okay.
draw-
AK Capac is no issue. We have seen that many a times.
We reported it in AIR SC 150, 1970 SC 150.
Sixty-nine two SCC 262.
Huh?
69 2 SCC.
69 2 SSC 262.
I've opened up AIR.
AIR
1970.
1970
70.
SC page 150.
Yes.
So here the basic case is that to constitute an all India service by the forest officers. Now, in order to constitute an all India service, an interview is to be held, required to be held. The conservator of forest was also a member of the DPC. And against him, there are some persons who are contesting the same post. This conservator of forest has taken an interview along with the other. However, when his turn came out, he went away. He went away. So in that case, it was considered whether it is fair or not. That he himself judged his own cause. The paragraph 20, probably I don't know whether it will tally or not. The aims of ritual justice. Got it? Paragraph 20. The aims of natural justice secured to put negatively prevent the miscarriage of justice. Got it? Paragraph 20.
Yes, yes.
Let me. The aim of natural justice, rules of natural justice, is to secure justice, or to put it negatively, to prevent miscarriage of justice. These rules can operate only areas not covered by laws validly made. In other words, they do not supplant the law of the land, but supplement it. The concept of natural justice has undergone a great deal of change in recent years. In the past, it was thought that it includes just two rules, namely, here is Miller, no one shall be a judge in his own cause. I am on this point, Miller. Nemo debate SS index properia cause, and no decision shall be given against a party without affording a reasonable hearing, or the alternative. And the first principle. Very soon thereafter, a third rule was envisaged, and that is that the quasi-judicial inquiries must be held in good faith, without bias, and
No,
not
there is a reason.
arbitrarily.
In this
All-
IKIK RIPAC, please come to paragraph 15.
15.
1-5.
One second.
This will give the answer. Paragraph
Facts.
15 is, you see from in the middle,
It is against the
but
canons of justice to make-
about 4 lines from above. But then under circumstances,
Yes.
it was improper to have included Nashik Band
Hmm.
as a member of the selection board. He was one of the persons to be considered for selection.
Yes, yes.
It is against all canons of justice to make a man judge his own cause.
Yes, yes.
Therefore, you see, if I am to be appointed and I am in the committee, then even if I go
judge
out,
his own cause.
no, even if I go out,
He recused, but then though he recused,
Yes.
but then he was
I'm-
the.
Yes. Yes, that is 100% correct. But why so? That has been explained here.
no, this is something we have make your submissions.
Yes, yes, 100%
Uh-huh.
correct. Right? No one shall be a judge in his own cause, such and such. No decision shall be given against a party without affording him a reasonable hearing, held in reasonable hearing. Very soon thereafter, a third rule was envisaged, and that is that the quasi-judicial inquiries must be held in good faith, without bias, and not arbitrarily or unreasonably. But in course of years, many more subsidiary rules came to be added to the rules of natural justice. The very recently, it was the opinion of the court that unless the authority concerned was required by the law under which it functioned to act judicially, there was no room for the application of the rules of natural justice. The validity of that limitation is not questioned. If the purpose of the rules of natural justice is to prevent miscarriage of justice, one fails to see why those rules should be made inapplicable to the administrative inquiries. Oftentimes, it is not, those are the days when the administrative inquiries, there was a basic difference between administrative inquiries and quasi-judicial inquiries. The administrative inquiry was beyond the purview of the natural justice. Now, subsequently, any action which affects somebody's, then it must be carried out with the principles of natural justice. That is the corporation there. Here that has been dealt. If for the purpose or rules of natural justice to prevent the miscarriage of justice, one fails to say why those rules should not be made inapplicable to the administrative inquiries. Oftentimes, it is not easy to draw a line that demarcates the administrative inquiries from the quasi-judicial inquiries. This is the very important line. Inquiries. Inquiries which were considered administrative at one time are now being considered as a quasi-judicial in character. Arriving at a just decision is the aim of both quasi-judicial inquiries as well as the inquiries, administrative inquiries. An unjust decision administrative inquiry may have more reaching effect than a decision of a quasi-judicial inquiry. As observed by Satyensad Bhattacharya, AIR 1969, ASC 198, the rules of natural justice are not embodied rules. What particular rule of natural justice would apply to a given case must depend or to a great extent on the facts and circumstances of the case. Natural justice are not embodied rule. What particular rule of natural justice should apply to a given case must depend to a great extent on the facts and circumstances of that case. The framework of the law under which the inquiry is held and the constitution of the tribunal or a body of persons appointed for that purpose. Whenever a complaint is made before a court that some principles of natural justice had been contravened, the court has to decide whether the observance of the rules, and that is not important. It was, well, let me read paragraph 21. It was next urged, that is the Attorney General's argument, that will not help me, Attorney General. Let me read.
Now you see from this AK Kripak, from AK Kripak, if you come to this judgment you are citing, Arjun Chaube, please come to this Arjun Chaube.
Arjun Chaube?
Arjun Chaube, yes.
Yes.
84, bro.
Yes.
Yes. Now please come to paragraph 5.
Paragraph 5.
Paragraph 5 is he is involved. The paragraph 5 is that he was the in charge of the employees and he's involved.
Letter dated dated May 21st, 1982, which contains the accusation of gross misconduct. The charge sheet himself is the accusation. When a charge sheet is issued, it is an accusation. The letter which contains accusation of gross misconduct against the appellant enumerates 12 charges. One charge sheet was issued and it enumerates 12 charges, out of which charge number 2 to 7 and 11 refer to the appellant's misconduct. Appellant misconduct in relation to the respondent number 3. For example, the second charge.
Respondent number 3 is the inquiry officer.
Yes.
He's the discipline. He was the disciplinary authority here. Respondent number 3 was the person who had terminated his service.
Yes.
Now read this.
Yes, I shall go through the paper document letter. Yes, let us see the response number. He is the person concerned. Let us bear it in mind. For example, the second charge is alleged appellant entered in the office of the respondent number 3 and challenged him in the offensive derogatory language. Charge number 3 says that the appellant was in the habit of forcing himself on the respondent 2 or 3 times every day with a petty complaints. Charge number 4 is alleged that the alleged appellant stormed into the offense of respondent number 3 and shouted him and using foul words. Charge number 5, 6, and 7 contain similar allegations. These allegations contain in charge number 11, 1 to the effect of behaving leader goods. Therefore, the appellant hired a service of the other gunda, etc., gundas, and created security problem for respondent number 3 and the members of his family. It is obvious that if an inquiry were to be held into the charge frame against the appellant, the principal witness for the department would have been the respondent number 3 himself.
Now, please stop here and come to paragraph 3.
Paragraph?
Paragraph 3.
3.
Yes.
The order of dismissing the appellant from the service was passed by the respondent number 3. Yes, here is also here it is. Same thing. And that is why I have selected this.
Okay.
The order of dismissing the appellant from the service was passed by the respondent number 2 under Rule 14(2) of the Railway Servant Discipline Rules. Read with proviso to Article 311(2) of the Constitution. Respondent number 3 recorded his reasons in writing. Here also, the divisional officer manager recorded his writing. The respondent number 3 recorded his reason in writing for coming to the conclusion that it was not reasonable practicable to hold an inquiry into the conduct of the appellant in the manner provided by the relevant rules, and therefore proceeded to pass the order of dismissal without holding any inquiry. Good. Now, here, okay, let me paragraph. Let me read the paragraph, entire paragraph. Department would have been respondent number 3 himself again the accuser. He's the respondent number 3 is the accuser. He who brought some allegation. Again, respondent number 3 himself the main accuser. And the target was furnished and the target of the appellant's misconduct. It is surprising in this context that the explanation dated 9 June 1982, which was furnished by the appellant to the letter of acquisition. Letter of acquisition means there is a charge sheet. That is what they call. Letter of acquisition dated 22 May 2082 was considered on his merits by the respondent number himself. Who submitted the charge sheet, he himself has considered it. It may so happen that he may be involved with some allegations. Respondent himself. Thereby the accuser becomes the judge.
He is the complainant. Respondent number 3 is the complainant.
Respondent 3 is the complainant. Anyway, respondent number 3 is the complainant. Respondent number 3 issued the charge sheet.
And he dismissed it.
3 hold the inquiry. Respondent number 3 issued the
No, inquiry was never held. Inquiry was never held.
In our case, inquiry also not held.
He thought that this inquiry could not be possible and therefore he terminated service.
No. Here also, in our case, the inquiry was not held.
Okay. Show us that.
Yeah.
Show us the facts of the case.
Here case, no inquiry was held. He simply called upon the delinquent persons. They were heard and order was. The appellant, the considered in marriage by respondent himself. Thereby, the accused become the judge. The letter written to the appellant on that true. Now, the appellant submitted. Let me skip it off what he had written, all these things. I have done all right. I have gone through your defense explanation dated 9/6/82 to the charges He has charges given in this office letter. He issued the charge sheet and he considered, and the same is not convincing at all. Before taking any action under disciplinary and appeal rules, I would like to offer you another chance for giving your explanation to the specific charges conveyed to you by this office letter dated 22/5. If
You see, what I've understood till now, subject to correction,
yes,
because I have a tendency to forget after all this, after
Even
so
I
many,
now
after
my
so
memory
many
has gone to the head.
determinations I'm taking up. You see, here, because of the CAG audit,
Yes.
a show cause notice is issued to you. So therefore, you have come for questioning of this 2021. Look at the, if you, what is it,
29
page,
2021, yes.
page 12.
That is page.
Show cause notice can't be quashed. Show cause notice can't be quashed.
Show cause notice?
Cannot be quashed.
21. No, what? Yes, that was the observation made by your lordship. The earlier order.
Yes.
That your lord, in the earlier order, your lordship was of the view that no show cause notice was issued. No, yeah, I'm reading the judgment order
So
again.
we have seen that on the last occasion.
But
But
no
here,
show cause notice
but-
was issued. They were not afforded with any opportunity of being
no,
heard.
now this show cause notice has been issued to you.
Yes, show cause
Why
notice
it should
has
be
been-
quashed?
So cause notice has been issued and your lordship made an observation that this order will not preclude the authority to hold a departmental inquiry by issuing a show cause notice. So what we understand from the departmental inquiry, a show cause notice has to be issued. Reply has to be considered. If you are not satisfied with the reply, then you have to
No, that we don't know. You see, please come to this page 42. Page 42 is that please find herewith document related to CAG recovery of so and so.
please enclose, please find herewith the following documents relating to CIG recovery due to wrong certification of outslave and the respondent departmental inquiry.
Yes, so it's on
All right.
focus notice.
These were furnished to us. Then, my lord, this is the CIG report. Then what happened? Ultimately, this order was passed. This is the order. You will also come to page 53 probably.
53.
53 onwards. No, 55. Detailed excess incentive recoverable amount from the period. Got it? 55. Not judgment of the not judgment. এর আগের টা। Page 121. This was the action taken.
No, I think, Mr. Dasgupta,
Yes, ma'am.
you see, subject to correction, what I remember is, in this case, there was a CAG audit. And because of that, they had issued a notice to you, to all the departmental labors on 29/1/40/2021, that is page 42.
Ah.
Correct?
Ah.
Along with this, there's only one annexure, which is the, which is
CAG
the
report,
CAG
report.
No. This is not a CAG report. This is,
Content of my
this is only a part of it, para 5. What is this? I don't know. You will see
Based on the CAG report.
page, you see page 41, 42, page 42, serial number 1, CAG para regarding excess payment. So this is only a part of it which is provided to you.
Yes.
Correct. Now, next you come, please come to this,
Page
what you call
48.
this, the internal letter of the department at page 48.
48.
This is 2015.
4/3/2015.
Yes. And this statement appears to be a part at page 53 onwards, appears to be a part of that. So 2015, you are not asking for question. You are asking for question of the page 42 notice, which is merely a show cause notice.
No.
It's not an action taken report.
No. Now your lordship come to page 121.
What is this?
This is what your lordship interfered with in the earlier 5 cases, 4 cases.
Your
And
lordship,
then your lordship said that you started making recovery without giving them an opportunity. Thereafter, we given them opportunity. These were not put to challenge. This were.
Show cause notice is not on, where is the show cause notice? Which page?
page 129,
That
your
is
lordship.
the, by way of affidavit, we have said during the pendency, we said we have pursuant to the order passed by this court, we held an inquiry, issuing show cause notice, and then passed an order. This order was never challenged.
Okay, I get it. Now I get it.
Page 129.
Yes, now I remember.
This order, orders
Page-
or show cause not.
Paragraph 8 probably. Paragraph 7. Page 132.
Yes, I now remember.
Thus, in other words, recovery is sought to be made from the salary of the petitioner without any finding to hold that the petitioners were guilty of fraud and or any other misconduct, and or that they are guilty of fraudulent withdrawal. All these things, fraud, fraudulent withdrawal of money sought to be recovered. There is nothing in the affidavit in opposition filed by the respondent from which it can be gathered that the amount of money sought to be recovered from the petitioner has been quantified. After putting the petitioner to the notice, the affidavit in opposition filed by the respondent have not produced any order in writing that was served on the petitioner before starting to deduct money from the salary of the petitioners. Now, therefore, it is very much important. Therefore, in the light of discussion above, the court is of the concerned opinion that the action of the respondent under the facts of the case is not found sustainable on facts and in law. And as such, the court has no hesitation to set aside the action of the respondent. Though the action of the respondent was set aside, but they have not acted upon that. They have already recovered the money was refunded to, not refunded to us. Then they initiate a proceeding of whereby show cause notices were issued, and they passed an order, whatever the deduction was made, that is correct. And that is according to them, it is a lenient view. It is not found sustainable on facts in law, and as such, the court has no hesitation to set aside the action of the respondent in effecting the recovery of money from the salary of the petitioners on account of alleged fraud committed by the respondent without disclosing before the court regarding passing any written order to the effect resultantly respondents are jointly and severally restrained from making any recovery from the salary of the petitioners on account of finding of in the CAG audit report.
Yes,
dated
I have
25
recollected that.
2008.
You
Now,
noted
Lord,
that.
one thing that your lordship has specifically observed, that is a question of fraud is involved. Whether an inquiry where the allegation of fraud is involved can be conducted summarily or not. Anyway, let me assume that the summarily it can be concluded. Second question is that the person concerned who issued the show cause notice, who heard me and who passed it, whether that is justified or not. I will try to pursue your lordship on these two aspects here. Now, your lordship was of the tentative view that your allegation amounts to commission of a fraud. And you have acted upon that allegation without holding any inquiry. And your lordship set it aside. However, the lordship specifically made a mention that you are at liberty to hold an inquiry. Now that judgment was passed on a particular case. Now they have applied these decisions to other cases. So we have pointed out this court, and this honorable court passed an order. That order is, I will not repeat it again.
We have seen that last time you placed that order. Last.
Yes. I will not read it again.
Page 200.
To bring all these record, bring all these papers on the record of the case. Accordingly, they have filed their affidavit whereby they brought certain documents were placed before the court. So I have an opportunity to go through those documents. And I came to the conclusion that even if we assume these documents are correct, then also no, then also their inquiry was not conducted in consonance with the principles of natural justice. Now, 146 page of the yeah. 146 पुस्तक है वो नहीं पढ़े Lordship. Let's start with that. Let's start with that. Open the other property. Page 146 page onwards. Starts from
Focus notice starts from 134.
134.
Last time you placed it. That's why we.
Yes. No, I will not go through the focus notice. It was issued by the divisional managers. Now, all the so-called notice, I now just point out on the one order. Same person, same signature. Let me and take any order. 146 page. I will just read out this order below.
Yes.
Whereas such and such, let it copy, whereas such and such, whereas such and such issued to such and such person by order dated 30/10/2021. That is a so-called notice. Whereas reply received from such and such person on 22/11/2021. Whereas personal hearing was held on 21/2/2030 and 20 December 21 in presence of DO committee at FSDDI. Whereas written reply submitted and given in the personal hearing has been examined by the undersigned. He is the person he will examine the undersigned. Sri Sirajal Kaur Sardar Mandal has stated and submitted as follows. Submitted the following. What he submitted, FSD NGC is a high transaction depot and receipt of numerous rakes are being done. Many wagons are, anyway, these are his reply. Many wagons are having CLT bags. Rain damage bags also received in the racks. The stocks received also have spiled and scattered bags. All these are to be stitched and refilled, etc. These will obviously be more than new gunny bags supplied, output, fillings, refilling bags. These replies I have reflected in my writ petition, paragraph 9. I will read it so required. All these are to be stitched and these will obviously more than new gunny bags, slipped out, output, refilling. Audit had no document to prove the excess certification in the audit report, except figure now new gunny bag supplied. No convenience, no connivance done as output work leaves work done is made by the depot himself. No misconduct done. That is our reply. Whereas it is undeniable, and in fact, the crux of the
Mr.
matter
Dasgupta.
is that as per CAG.
Mr. Dasgupta, I
Sorry,
have to
sorry.
rise because there is a full court.
Sorry, Miller. Tomorrow can be Miller. কালকে হবে না কালকে তোমরা লিস্টে তৈরি হয়ে গেছে let it be 16th or so. Any other day, subject to your lordship convenience. Any day. Tomorrow will not possible because now 4:30. All these things are 3/5 here.
No. If we want, you can be listed. There's no issue. Listing is not an issue.
If your lordship challenging.
No, if it is your inconvenience, it's a different matter.
No, I don't have any. No, I am free.
Then it will come. Then it will come tomorrow.
Yes, second up. Or is the first up also? I am
No, it will come in this last part only. Because otherwise the list is out. Single bench will be only special bench. That's why.
Your lordship will have a DV tomorrow also.
Tomorrow, after DB, no?
After DB. It will be always this
At
time.
any time, I will do.
3 o'clock will be splitting up.
3 o'clock. I'm sorry, Millard. Okay, double here. Ek kitab se get the boda.
Mr. Dasgupta, the anxiety is only one. With the change of determination, I have the tendency to forget.
No,
So
this
I
is
don't want
very
your
much
effort
with
to.
me.
I don't want your efforts to go in vain because.
That is why, in fact, my lord, we submitted the written notes of it.
But
We have
your
submitted
lordship-
the written notes of that. It is only because of that, my lord.
Yeah, after all, your lordship is taking tremendous load.
But,
Foreigners
you know,
tribunals
that is
case,
part of the-
criminals case, foreign, I have to check up the.
Sometimes we
I
wonder,
have
my
checked
lord,
up yesterday night, I checked up the case.
Today is 1, 2, 3.
Foreigners tribunal, criminal case, again this. case.
sometimes we
No, there's a
wonder,
full
my
bench
lord,
also.
how will
At-
we cope it.
At 2 o'clock, we had a full bench also.
That's right.
So this is 1, 2, and 3.
We really wonder, my lord, how
No,
lordship.
that is.
No,
But I have,
70, 80 matters.
your lordship
Mr. Roy, it all depends on the on your what you call
master of.
No, no,
rest of-
on your zeal to do things, because we have seen both of you having immense roaring practice.
No,
You may have 15, 20 cases, but you could still manage.
That's right.
no, yesterday I have checked up this, I have to scrutinize the cause list, especially a lordship's cause list. My good God. Foreigners mean.
No, it depends, because you see, we have seen Mr. Dasgupta, we have seen you. You had a huge roaring practice,
No, no,
but you
that's
could
not right.
manage.
No, so
all the
far the
cases.
lawyer is concerned and judge is the first of defense. A lawyer may conduct 5 or 6 cases daily, maximum. But
No,
judge
we
has
have
to
seen you
take-
doing more.
Judge has to take.
No, no, but then your lordship will have to deliver a judgment and it will be judgment for all times to come. That is, there lies the difference.
No, sometimes. Real is a
this-
very tough job.
Daniel? Remains inconclusive. Mr. P.K. Roy, done at senior counsel, assisted by Ms. P. A. Chakravarti, learned counsel, remains, is present. List as a part and matter on tomorrow.
By this time, probably your lordship's taken on a larger bench matter. Today,
Yes.
That's already over.
Already
At 2. Now is a
no,
meeting.
division bench, larger bench, criminal bench, again this.
Now we
It's
have
too
a,
much.
now we have a, what do you call it? It's almost a, what do you call, on administrative side, there is a meeting.
That's again, it means to decide. Then again, at the night, you have to go to that meeting.
So even in lunchtime, we had a meeting.
Well, it should be